Thank you for watching, as always. In this installment of the AI Governance Textbook series, we will explain AI-related laws. Last time, we covered the EU AI Act, which directly regulates AI itself. However, real-world AI deployment is not driven solely by the EU AI Act. This is because, in many practical settings including Japan, AI-related laws often constrain enterprise deployment before AI-specific laws become the primary issue. While the Japanese government has issued guidelines for AI businesses, they are not a comprehensive, legally binding framework like the EU AI Act. That is precisely why we must not overlook AI-related laws in addition to AI law. The essential laws that must be reviewed in Japan include the Act on the Protection of Personal Information, the Copyright Act, the Telecommunications Business Act, and the Product Liability Act. For instance, the Act on the Protection of Personal Information restricts the collection, use, and third-party provision of personal data. The Telecommunications Business Act can constrain aspects of how user inputs, logs, and external transmissions are handled in AI-enabled services. These laws do not directly classify the risks of AI. However, they stipulate whether the AI handles data legally, whether external transmissions are lawful, and how liability will be assigned in the event of an incident, thereby imposing constraints on the fundamental design of production deployment. This is the crucial point. While the EU AI Act directly regulates AI itself, AI-related laws govern the periphery: the data AI uses, the outputs it generates, the form of service delivery, and liability if something goes wrong. Therefore, in corporate practice, merely complying with the EU AI Act is insufficient. Failing to navigate AI-related laws, including the handling of data and communications, will inevitably create a barrier to enterprise deployment. This means that AI law and AI-related laws do not compete, rather, they act as overlapping constraints operating on entirely different axes. What is necessary in the AI era is not merely knowing AI laws like the EU AI Act. In practice, we must look comprehensively at AI-related laws as well. The real question is not whether you can name the laws, but whether you can anchor operating conditions as evidence across multiple legal constraints. Next time, we will systematically review the essential AI-related laws that Japanese companies must understand, and specifically examine which laws block AI deployment in which scenarios. The critical factor is not mere compliance with AI law. It is whether you have anchored your operations in a way that preserves responsibility, encompassing all AI-related laws. This has been Ghost Drift Mathematical Institute.